We're going to do Roe v. Wade. I think everyone taking this class is familiar with Roe v. Wade. So I'm going to outline a few things that might not be apparent to those who are just cursory, familiar with it on a cursory level. And also focus to some degree on the concurrences and dissents, not because they're any sort of binding precedent or they persuade the court going forward, but because of what they say about substantive due process. Because I want to focus the string to a degree on how substantive due process evolves over time. And Roe v. Wade is a significant example of the acceptance by a significant majority of the courts, 7 of them in this case, that substantive due process is back, and it's a good thing, and that's how we're going to incorporate rights going forward. So a pregnant single woman who had alleged she had been raped was prohibited from obtaining abortion in the state of Texas because a state law made it a crime to attempt abortion on a woman except to save the life of the mother. So the issue in this case was whether the right of privacy, as announced in Griswold, covers the decision of the woman to have an abortion. And in a 7-2 majority, a very significantly large majority, the court says yes, that it does, that the right of privacy includes the individual right to an abortion. But before we deal with that part, I want to deal with one other part. And the court had to deal with one other part too. And that was, first, why wasn't this case moot? Because by the time the case had already come around and already was before the court, the woman in the case had already given birth, which means that the state's prohibition upon her ability to have abortion was moot. The child was born. And so the court has to wrestle with how to deal with the mootness doctrine with regards to pregnancy. And so the court issues a rule providing that if an issue can come up consistently and again, so again and again, that the judicial system, because of its slow nature of response, will miss it, then that issue isn't moot because it can occur again. The actual standard is capable of repetition yet evading review. And so the court issues a rule that the case is not moot because the woman in this case could become pregnant again and would be subjected to that Texas law again. And because of the nature of how justice works in the United States, that within the 9-month time span, the court would probably, the United States Supreme Court would probably never be able to issue a decisive decision if they didn't modify the mootness standard. So mootness in a significant way gets modified in Roe. With regards to the merits of the case, Justice Brennan writes that there exists that the constitutional right to privacy, based within the penumbras of the Bill of Rights and the 14th Amendment, that include a broad definition of marital and sexual-based privacy rights, also include a fundamental right to have an abortion, largely because leaning on previous precedent, so for example, precedent in Skinner, the precedent in Griswold, and the precedent in Loving, that there exists a fundamental privacy-based right to marriage, procreation, and children. It's not a far extension of the right, the court argues, if contraception is part of the right, to extending the decision to terminate a pregnancy. In fact, Brennan writes that the right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. So if the woman has control over the determination of whether she gets pregnant, i.e. the use of contraceptive devices, then the right of privacy is broad enough to also encompass the decision that woman makes whether or not to terminate her pregnancy. The court really doesn't do a whole lot of analysis with regard to why this right, why abortion is included in privacy, um, outside of simply discussing contraceptive use. And so it doesn't wade really into the moral aspects of this decision. It kind of sticks away from it. Although the court does deal with the idea of the sort of constitutional standing of the fetus. They argue that, foremost, because the 14th Amendment provides protection to any person, they had to determine whether the fetus was or was not a person. And Brennan writes that when those trained in respective disciplines of medicine, philosophy, and theology are entirely unable to develop any consensus on when life begins, the judiciary at this point in the developments of man's knowledge is not ready to take a position speculating as to the answer. So simply, we're going to say that life begins at birth because there exists no consensus within the areas of medicine, philosophy, and theology about whether a fetus has rights. And so the court argues that this isn't a moral or philosophical perspective, it's simply a legal rule, and that legal rule is based upon the fact that there exists no consensus within areas that specialize in the discussing of morality and philosophy and theology. So while the court rules that there exists a fundamental right to obtain an abortion, they significantly limit that right as well. They argue that it's not absolute and there exists limitation upon rights to privacy even within an abortion. They argue that the woman's right to obtain an abortion has to be balanced with the state's interest in the health of the woman and in protecting potential life. The state very much so has an interest in seeing that population increases, and therefore the state has a role to play in this environment. That this abortion right, like every right in the Constitution, is not an absolute, and there exist limits that balance against that right. This is perhaps the most questioned and notorious part of this decision. Because the majority opinion articulates a framework in which to discuss how this balancing plays out. And that framework is known as the Trimester Framework. So the court argues that within the first trimester, the state has absolutely no interest in the unborn fetus, and thus the woman has to have unfettered right to obtain an abortion without any state intervention. That shifts in the second trimester, that the state does have an interest in the health of the woman, but not of the fetus. And thus the state can regulate how abortion proceed with regards to a woman's health, but the state cannot stop a woman from obtaining abortion during the second trimester. So the state can now regulate in the second trimester, but those regulations are for the health and safety of the mother, not with regard to stopping the woman from attaining an abortion. Within the third trimester, this shifts. The state has an interest in the life of the fetus at this time because the fetus is now viable outside of the womb. And thus, the state can prohibit abortion entirely at this time if it chooses, although the state can still maintain an interest in the woman's health. So the reason why that the third trimester was different from the second and first trimesters is because of fetal viability, meaning that within the third trimester, generally speaking, fetuses are able to survive external from the uterus. And because of that, the court says that the state's interest increases because that potential life is that much closer to actually being life. And barring where it is, it could exist outside of the mother. And so the court sets up this trimester framework by which to judge laws that infringe or inhibit or regulate abortion, because they realized, the court easily realized, that one, this was going to be a controversial decision, and two, they had to provide guidance to lower courts with regard to laws that regulated this practice. So this trimester framework proves to be exceedingly problematic because some of the assumptions of the trimester framework that the court articulates are based upon current statements regarding viability. We know now, sitting in 2019, that a fetus is medically viable significantly earlier than the beginning of the third trimester. Basically, medical science has improved to the point where fetal viability, external from the mother, has gotten closer and closer to conception, and the trimester framework doesn't mesh that well with medical science. Also, it's generally unwieldy, and that was some of the critique that abortion rights activists had of the framework, is that it proved unruly. But it seems pretty clear that the court going forward at least set guidance for states and for lower courts with regard to how to proceed with laws that regulated abortion access, and health and safety of the mother and fetus. Let's transition to a look to the concurrences and dissents. One that I definitely want to call your attention to is Justice Stewart's concurrence. Remember, Justice Stewart dissented in Griswold, and his dissent was entirely based upon the argument that substantive due process and rights involving substantive due process should be left to legislatures and not courts. He concurs in this decision. He dissented in Griswold, but he concurs in Roe v. Wade. And he argues that substantive due process is alive and well concerning fundamental non-economic rights, and I now accept it as such. In essence, I was wrong in Griswold. There now exists a precedent on the court that substantive due process rights in non-economic areas are acceptable, and I accept it to be the trend of the court and the precedent of the courts. So Justice Stewart comes on board. Justice Douglas also concurs. But Justice Douglas's concurrence is a concurrence in the outcome and not in the reasoning, because he, in essence, is arguing the position of Calder v. Bull, asserting that there exist certain rights that fall within the blessings of liberty, and not that the substantive due process is the method by which to read it into the Constitution. There were two judges in dissent, Justice White and Justice Rehnquist. Justice White argues, in essence, Justice Stewart's dissent from Griswold, because he says that there's no such thing as a fundamental right for courts to protect. That shouldn't exist. Substantive due process shouldn't exist. And all of these questions should be left to the political process, meaning legislatures. Judges like to use that phrase, left to the political process, without recognizing that they're absolutely involved in the political process. So when judges invoke this should be left to the political process, what they're saying to is legislatures should actually handle this. Justice Rehnquist's dissent is significantly broader than Justice White's dissent. Justice Rehnquist says that he absolutely agrees with the notions that fundamental rights exist and that the notion of liberty is somehow broader than the rights enumerated within the Bill of Rights. So he assuades and says that, yes, there exist fundamental rights and there exists liberty beyond what is provided in the Bill of Rights, and that the Constitution does protect them. But those rights are not absolute, such that a person can be deprived of those rights as long as there exists a due process of law, that the due process of law can violate any right, and that includes these fundamental rights that are read into the Constitution. His argument is that the state law was passed in a constitutional manner. It met all constitutional muster, that the law was absolutely rationally related to a state objective. There was due process involved. And then the right of an abortion, thus, if there's due process involved in a constitutional fashion, whether that abortion right is fundamental or not, it absolutely can be restricted, as any right can be restricted. I'm less persuaded with him to regard in that argument. But Justice Rehnquist also makes a very, very good point that I think is quite telling of the decision. He notes that the majority opinion quotes Justice Holmes's dissent in Lochner. And Rehnquist argues that there is a degree of irony to that, because the court's decision in Roe v. Wade is more closely attuned to the majority opinion in Lochner than Justice Holmes's dissent in Lochner. In essence, he's calling out the majority for engaging in the same sort of judicial legislation that existed in Lochner that also now exists in Roe. And his argument is, in essence, if you're going to quote a dissent in a case that institutes a broad use of substantive due process rights to incorporate things into the Constitution, then you have really no true legal grounds to make a decision that uses substantive due process rights to read something into the Constitution. So Justice Rehnquist's dissent is fairly telling in this regard. And so the time after Roe, and in the next case that we do, really deals with determining what the confines of the right to an abortion are. Sometimes the court moves forward using the Trimester Framework, sometimes it doesn't. And there are many limitations upon Roe. In fact, the true history of abortion rights in the post-Roe v. Wade era are determining what limitations exist. It's not a broadening in any sense of the right articulated in Roe v. Wade, but it's a constriction of the right articulated in Roe v. Wade. And the cases that we do going forward are a determination of what restrictions pass constitutional muster. And I can give you a few now, just to sort of put this into context. So some things that the Supreme Court has accepted regarding limitations on the right to Roe. A prohibition on public funding of abortions. A determination of viability after 20 weeks. Informed consent about the effects of an abortion. A waiting time between an informed consent and the procedure taking place. Parental notification. All of these are seen as, at least by the court, legal limitations upon the right. But understand that when this decision was articulated in 1973, we had a somewhat liberal court. Not as liberal as the 1960s, but still with many justices as holdovers from that era. As we move forward through Presidents Reagan and President Bush, the court becomes more and more conservative. And at the time that there exists 5 conservatives on the court, there was significant worry among abortion activists that the right to an abortion would be taken away by the 5-4 majority that the court would have going forward. And that doesn't happen. And one of the reasons that doesn't happen is because of the first woman to join the United States Supreme Court, Justice Sandra Day O'Connor.